Hey, I'm Paul Rabelais, and in this video we're going to talk about who can be an administrator of an estate. All right, so this comes up from time to time, came up last week in my office. So let's start with the basics. Many estates of people who pass away, many of those estates require what I'm going to call an administration. An administration of an estate is necessary or required when things need to be handled during this time from the moment the person dies until the estate runs through the court process and assets ultimately are dispersed to the heirs. That doesn't happen in one day. Sometimes it takes months or years. And so sometimes an administrator needs to be appointed to handle the administration of the estate. So, again, reasons administrations are necessary. Sometimes the deceased may have had a home or property that needs to be sold during the administration. The administrator would handle that. Sometimes people pass away and they have debts that need to be paid. They have mortgages, they have credit card debt, they have other debt, and that debt's got to be paid while this administration is going on. So the administrator, collects the funds and makes sure the debts get paid. Sometimes the administrator needs to hire lawyers and accountants to handle things while the administration is going on. Sometimes someone dies and their investments need to be managed during the period of the administration. And then sometimes a business owner will die, and so an administration is necessary to appoint an administrator to continue the business operations of the business that the deceased person owns. So those are just a few of the reasons why an administration is necessary. And if someone dies and they have a will, in their will they're going to name their executor. So it's the executor who handles the administration. If someone dies in an attempt to avoid probate and they have a revocable living trust and their assets are titled in the name of their trust, the person who will handle that after the trust maker or trust settlor dies, that title is called successor trustee. But if somebody dies and they got a bunch of stuff all over the place and they have no estate legal documents in place, then they are considered to have died intestate without a will, and a judge or a court will have to appoint an administrator to handle the stuff that needs to be handled while that administration is going on. So let me give you an example that really brings all of this to light. Let's call him Big Shot. So Big Shot died and he never got around to doing any kind of estate legal planning for himself. He was too busy. He had a bunch of wives. He was on his third marriage. He had kids and grandkids. He had kids from his first and second marriage. He's now in his third marriage, or at least he was when he died. He owns several different pieces of property with other property owners that he knows, his buddies. He owns a partial interest in some businesses with some business partners of his. Big Shot owes the bank. Big Shot owes on some credit cards. And after Big Shot died, it becomes fairly well known that Big Shot had this other woman on the side. We'll call her Side Woman. And she comes out and shouts from the rooftops, "I can't believe Big Shot died. He promised he would take care of me." So all that stuff is going on. So it becomes pretty obvious that there's things that need to be handled. So there's going to be an administration of Big Shot's estate or probate, or in Louisiana succession, whatever you want to call it. So why would someone want to become an administrator? I think essentially two reasons. The first reason is administrator compensation. So the administrator that's appointed by a judge gets compensated for their efforts out of the estate. So we've got a provision on that. And let me make sure I get the wording just right. All right, so here's our provision. And these are Louisiana procedural rules. I'm sure your state has something similar, but this will at least give you some guidance as to what Louisiana and what another state might do. It says in our rules that the administrator shall be allowed a sum equal to 2 1/2% of the amount of the inventory as compensation for his services in administering the succession. So let's say Big Shot had a really big estate. Let's say he had an estate that was valued on his inventory at $10 million. Well, 2.5% of that is $250,000. So that's what the administrator's compensation would be. Good work if you can get it. So that's one reason maybe why someone would want to be appointed as the administrator. But really, I think that the main reason someone would want to be appointed as the administrator would be that as the administrator, they get to protect whatever their interest is in their estate. Maybe it's a child of Big Shot who is inheriting from Big Shot and is inheriting some of the land and the business and the investments. And that child wants to be appointed as the administrator so they can, make sure stuff doesn't go away and stuff gets managed while all this is going on. Maybe Big Shot's wife wants to be appointed as the administrator for the same reason. She wants to make sure, her interest is protected. Maybe some of those co-owners of property with Big Shot want to be appointed as the administrator because maybe some property now needs to be sold or leased or whatever, and that co-owner of property with Big Shot as the administrator can handle that kind of thing. Maybe one of Big Shot's business partners who owned a business with Big Shot would want to be appointed as the administrator so that that business partner could continue to run the business and run Big Shot's portion of the business as the administrator of Big Shot's estate. So, or maybe one of these lenders of Big Shot wants to be appointed as the administrator so they can make sure their loans are protected and they're going to get paid back. Maybe the side woman wants to be protected because heck, Big Shot said he'd take care of her. So all of those are some of the reasons why someone would want to be appointed as an administrator. Now, this doesn't happen much because, as you can kind of tell from example, there's a lot of different moving parts and a lot of different conflicting interests in Big Shot's estate. But occasionally it happens where when somebody dies, some interested person files a petition at the courthouse to be notified when someone applies to be appointed as the administrator. So any interested person has the right to file, the appropriate procedural documents at the courthouse and say, hey, if somebody applies to be appointed as the administrator, I want to know because I might want to oppose their application. So, and then when someone does apply to be appointed as the administrator, they are required to give notice to that person who asked to be notified, and then there will be some hearing. And when the position of administrator is claimed by more than one person, there's a list of who has priority to be appointed as the administrator. So let's go over that. All right. So let's see here. That one is going to be right here. Okay, so when the appointment as administrator is claimed by more than what's called one qualified person, and there are people who just can't be an administrator, somebody who's under 18, somebody who's been interdicted or declared incompetent, a convicted felon. So there's a list of people who just flat out can't be an administrator. But when the appointment is claimed by more than one qualified person, preference in the appointment shall be given by the court in the following order. So there's three. This one first. If there's not one of these, it's going to be one of these, and if it can't be one of those, it's going to be one of these. So when there's more than one claimant to a person who's asking to be appointed as the administrator, the top priority goes to the best qualified among the surviving spouse, competent heirs or legatees, or the legal representatives of any incompetent heirs or legatees of the deceased. So essentially that means whoever's most qualified out of the spouse and the heirs, that's who a judge would first pick and say have top priority to be appointed as the administrator. But let's say no spouse or heirs ask to be appointed as the administrator. Then it goes to the best qualified of the nominees of the surviving spouse, competent heirs, legatees, blah, blah, blah. So second priority is whoever any of those spouse or heirs nominate. So that's the second order of priority. And then the third, kind of bottom on the pecking order, but at least they're qualified to be an administrator. But third on the pecking order list is the best qualified of the creditors of the deceased, or a creditor of the estate of the deceased, or a co-owner of immovable property with the deceased. So that's who can be an administrator. First, it's the spouse or heirs. Second, it's whoever the spouse or heirs nominate. And third, it's the creditors or co-owner of property with the deceased. All right, and so let's go back through the list and see who could have been the administrator. So Big Shot had a lot of people he was dealing with. One, he had a surviving spouse. So maybe she would petition, and if she's qualified, and you know what, there's a definition for who's the best qualified in our statute. I probably should have mentioned that. Best qualified, as used in this article, means the claimant best qualified personally and by training and experience to administer the succession. Okay, so the spouse, maybe the spouse applies to become the administrator. She's in that top level there, so if she can show through training and experience that, you know, she's got the skills to do it, maybe the judge would appoint the surviving spouse. The deceased had children and grandchildren. Now, the grandchildren couldn't be, or any of the grandchildren could not be an administrator, because let's say Big Shot had 3 kids and 9 grandkids. Children were still alive. Well, the children are heirs, but the grandchildren are not. So a grandchild in this case could not be an administrator. A child could. Big Shot owns some property with other people. So if the spouse and the kids, you know, won't do it or can't do it, then it is possible that a co-owner of property with Big Shot could be appointed as the administrator. What's a little unique is Big Shot had business partners, and there's no provision in our statute for a business partner to be appointed as the administrator. And I would think that it would be pretty important for maybe a business partner to be appointed as the administrator to keep the business operations going, but there's no provision for business partner. Big Shot owed the bank. He owed the credit card company. So it is possible for a creditor of the deceased to be appointed as the administrator, and I get that. Now, the woman on the side who's shouting from the rooftops, "I can't believe Big Shot died and he promised he'd take care of me," no chance she's going to be an administrator, but she's just going to keep yelling from the rooftops. So as a side note, maybe with side woman, I don't even like talking about side woman, but maybe if he wanted to take care of side woman on the side, he could have put some money in a revocable living trust, all for Big Shot while he was alive. But the living trust would have said when Big Shot dies, the assets of the living trust go to side women. All of that would have been very public. Nobody else would have known about it. So just a little side discussion on, you know, how to leave stuff to somebody and make it really private. But that's not the topic of this. This is who could be an administrator. So really important, and sometimes it's really important to act fairly quickly when somebody dies. If there's the potential that more than one person is going to make the request to be appointed as the administrator, and you got to follow the rules. You can't just say, you know, that's not fair, or, you know, I wrote a letter to the judge. And, you know, you got to follow the rules, and it'll all sort itself out after, you know, time and expense and delay and money and all that stuff. But just wanted to make you aware of what some of those rules are on becoming an administrator of a Louisiana estate. So here's what I need you to do. Real important to me, if you could hit the subscribe button and the notification bell that pops up. That way you won't miss anything as I continue educating people on these important estate matters. And if you've already subscribed, thank you. That's fantastic. Smash the thumbs up button would be really cool. And any kind of, you know, comments where you can contribute to the conversation would be ideal. Preferably the kind of comments that might get proofread for grammar and spelling and some of that, and have some thought put into them. Those are my favorite kind of comments. So, all right, every morning at 10 a.m. will be a new video on how to protect your estate, educating the public. So we will see you at 10 a.m. Central Time tomorrow. Have a great day. See you tomorrow.